Stephen A. Williams, president and founder of the CreditRepairShop.com. You're going to want to listen to this video. CFPB has taken another big hit. They are being sued in court by debt collectors over medical debt collections. Now, we know under Biden they had a order where they were not going to have medical debt show up on your credit reports anymore. If it was under $500, you could say that that is going to be reversed. And I got some proof here from debt collector organization that is actually suing the CFPB. They are suing the CFPB for overreach. And it's going to be very interesting when I share with you the other things that they're stating about the CFPB itself on how they are actually going after individual companies and their funding source. This is something that there's been several lawsuits. The countersuit back, or the defense that was used, was that the CFPB had unconstitutional funded, like they were funded unconstitutionally. It did not work in a lawsuit that Lexington Law countered with that in their defense, but that was because there was a different administration that was in charge. And that was because regardless if the CFPB knew that they could just continue going and refiling the cases because of the administration that was involved. And also the ones that lost their cases that did utilize the defense within their defense, it wasn't their only defense, that utilized within their defense that the CFPB was funded unconstitutionally, they had other issues with their case. So even if they scratched that out of there, I believe that they were going to lose their case. But this one here, you're going to want to hear about it. You're going to want to hear about it because this is, if you have medical debt, or just regardless if you have medical or debt or not, you're going to want to listen to this because this is the way that things are going right now. This is the future of how debt collection is going to be handled post January 20th, 2025. This is how stuff is going to be moving forward. Now, let me go ahead and calm people down real quick, because I do have some good news also. The way that stuff is going to have to be taken care of for repairing your credit, dealing with these debt collectors, you want to know what I say is going to be? It's going to go back to the old style, the grinding it out old style of credit repair. There is no AI that's going to get on the phone with anyone, and I got a file right here. I was just on the line. It took me an hour of speaking with 2 debt collection companies and 1 credit card company and 1 attorney. Individual was getting sued by two attorneys, getting sued and had 2 collections. This will all be resolved within a week because this client is very motivated to get stuff resolved. But this is gonna be the way that credit repair is gonna be moving forward. It's gonna be back to the way that I established my company. Was, if you go back and look at my video that I did way back in 2006 that said what makes us different, and I said that there was a line down the middle. And on that line down the middle is that we dealt directly with furnishers, that we dealt directly with debt collectors, we dealt directly with original creditors. And this is something that other companies don't do. They don't know how to do. They're afraid to do it. All they want to do is just process letters and get away with stuff the easy way. Utilize AI and all of that stuff, which there's nothing wrong with that. But I'm telling you, the way that stuff is going down, you're going to have to be working with someone that's going to get people on the phone, because it's going to take some work to get stuff resolved. I call it the grind. So now, let me talk about let me just read it to you. Let me just read it to you, and I'm going to put the links to the article. It says here on November 1st, several debt collection trade organizations sued the CFPB, the Consumer Financial Protection Bureau, in District Court of the District of Columbia. I'm going to also put a link to the actual lawsuit itself. So it says here, plaintiffs allege that the CFPB violated the APA when it issued an advisory opinion on October 1st on collecting medical debt covered by the InfoBite. That I guess that was another website that covered it. The plaintiff claimed that the advisory opinion interpreted by the FDCPA, Fair Debt Collection Practices Act, to establish new rules without public input as allegedly required by the APA. The plaintiff claimed that the CFPB implemented new rules under the Fair Debt Collection Practices Act, such as a requirement for debt collectors to review account-level documents before sending a validation notice, a requirement for debt collectors to apply a reasonable standard for determining the amount to be collected, rather than relying on collection amounts stated by the original creditor, a new definition of debt in default, and a mandate for medical procedure audits to ensure billed procedures were actually performed. The plaintiff argued these new rules impose new obligations on debt collectors and the health care billing industry. I'm going to stop right there real quick. I could say that with the credit repair shop, medical debt was where we cut our teeth, where we got on the phone with these collectors, went back and forth, also making sure that there was no violations with procedures being shared with the debt collection company. You have HIPAA rights, but they also have a right to try to collect on the debt. It's like they're walking a tight wire. If you don't know what to watch out for, they're going to be violating your HIPAA rights. And but this was something that we cut our teeth on. We were very good at this, and we still handle people with this issue to this day. So now, in addition to claiming that the CFPB failed to follow the APA's rulemaking procedures in adopting the advisory opinion, the plaintiffs further contended that the advisory opinion exceeded the CFPB's statutory authority, as Congress did not delegate regulatory power over health care to the CFPB. The plaintiffs assert that the CFPB's jurisdiction was limited to financial products and services, and the advisory opinion extended the health reach illegally into the health care sector. The plaintiff also argued that the advisory opinion should be set aside because the CFPB was funded unconstitutionally due to the federal lack of profits since September 2022. This is not the first time that litigants have argued that CFPB was unconstitutional following the decision of CFPB versus CFSA. To date, courts have continued to agree with the CFPB's funding structure is legal. That was to date. That was now. To date. What do you think is coming up later? I've shared in other videos about what's going down in the courts right now. Overall, the plaintiff's assertion 5 counts against the CFPB in violation of the APA, failure to engage in notice and comment rulemaking, arbitrary and capricious actions, failure to observe certain procedures required by law, exceeding statutory jurisdiction, authority, or limitations, and the unconstitutional funding structure. The complaint sought an order vacating and setting aside the advisory opinion along with other relief. Now, if you watch my other video where I stated that the CFPB was, I believe that CFPB is going to be gone, because I've heard this over and over and over again. They keep putting this in the law, in the defenses, but this is the first time that I've seen it where it was actually where the plaintiff is the suing that CFPB, and they still put that in there about their funding structure. Just in case you don't know, the CFPB gets a lot of its funding from suing companies, and they will actually get funded with the money, the proceeds from the lawsuit. A lot of people do not like that because they believe that the CFPB, instead of having complaints come to them, that they're actually out there actively going after companies to make cases. This is just what's being said. This is what's being said. So now, in the video that I made earlier in the week, I stated that under the new administration, they asked, and now it looks like they're going to have the Senate and the House, that they wanted a 60-day pause. The move that this debt collection organization just made will allow that to be in that 60-day pause, and I believe that right after that, the CFPB will, under new leadership, under new orders, knowing that the executive branch is not going to back them, knowing that really, I mean, who's gonna back them with their independent? Independent, but they still have to follow certain guidelines, and if their power is taken from them, how are they going to be able to move forward? I don't know how they're going to be able to move forward. Concerning to me is that it's going to kind of open the gates again to a lot of medical collections being placed on credit reports. You better bet that the next thing that they're going to say is I don't know if I'm going to use the right word, but that they owe the authority of the executive branch to, because I believe that the medical debt not being recorded is an executive order. So that executive order could be rescinded if it is an executive order, and then medical debt will just be plastered all over your credit reports again, making a domino effect of making your scores go down, making a domino effect on affecting the interest rates that you're going to be paying because your credit scores are lower than they were, even though you had that medical debt that wasn't being reported. So now what are we going to do about it? What are we all going to do about it? What we're going to do about it is not stand still. What we're going to do about it is we got to make sure that we get stuff corrected on our credit reports, get it into the best light, settle debts what needs to be settled so you can move forward. Because regardless of what's going on the outside, regardless of this stuff here, it just makes you have to fight stuff a different way, but you still can resolve stuff. It's just going to make it to where there will be a lot of work. And I've talked about this in my videos in the past. I know that a lot of people want to get these quick fixes and all of that stuff. You better bet a lot of that stuff is going to be, it already should have been off the table, but it's going to be even more off the table. Because that stuff won't work. That stuff is just going to get you into a worse situation. It doesn't matter how long it takes you to get yourself resolved, to get your credit back in order. If you take the time to do it, time is still going to pass regardless. All right, I'm going to put the link to this article in the description. I'm going to put the link to the lawsuit in the description so you can know that you can read it completely so you can see what's going on, but I just did a brief summary of it. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and scores. If you have debt collectors coming after you early, including medical debt collectors, grab my 3-pack of letters, statute of limitations, debt validation, cease and desist, collection activities letter. Thank you for your time. Subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.